Okay, good morning.
Good morning.
Okay, we're here for oral arguments on the case of Little Brownie Properties versus Wood and Brown, case 20-2409. My name is Kerry Evander. Let me introduce the other members of the panel sitting today, Judge John Harris and Judge Dan Traver. These oral arguments are being live streamed and being recorded. I noticed the appellees, we have two attorneys present, one for each of the appellees. Have you all decided how you wish to divide your time?
Yes, Your Honor, we have.
Okay, and how will that be divided?
We will split it evenly. Attorney Trombley will go first and I will go second.
Okay. Do you want any type of warning, Ms. Trombley?
1 minute would be great. Thank you, Your Honor.
All right, and the appellant has entitled to divide their time between the opening argument and rebuttal argument. Mr. Mashburn, how much time do you want to reserve for rebuttal?
5 minutes, Your Honor.
Okay, I'll try to help you in that regard, but there is a clock on the screen. And with that, Mr. Mashburn, you may proceed.
All right, good morning. May it please the court. My name is Eric Mashburn. I represent the appellant, Little Brownie Properties, in this matter. I believe this appeal presents to the court a policy decision that has ramifications beyond this particular case. The issue before the court is the meaning and implementation of the judicial rule of statutory strict construction. That was the basis the trial judge used to justify his decision to dissolve the writs of garnishment in this case. It appears to me, however, that the rule of strict construction is often invoked or cited in case law, but without a very thorough analysis of what is actually meant and how the concept is to be applied in differing fact situations. So I am advocating that the court adopt an interpretation of strict construction that is not absolute and unbending, but that takes into account differing circumstances in particular cases. And when that version of the rule is applied to this particular case, requires the reversal of the trial judge's decisions in dismissing the writs or dissolving the writs. So my proposal can be summed up as basically as follows, is that if a particular statute that mandates an action by a party states that and states a time limit, for instance, within which that action is to be taken. And if the statute states that if that action is not done within the stated time, then there's a stated consequence, then the court is duty bound to follow the dictates of the legislature and to honor the statutory language as written. If, on the other hand, if the statute is silent as to a consequence of a failure to do something that's otherwise required, then obviously the legislature has not expressed its intent as to what the consequence should be. And by default, the decision's left to the trial court to decide what the remedy or what the consequence should be. And I believe that in making that decision, the trial court should take into account the individual particular circumstances surrounding that particular breach of the statute.
Mr. Mashburn, let me ask you this. The statute doesn't appear to make provisions for a party to ask for an extension of time. Is that a factor for us to consider?
Well, yes, sir. I think obviously if it did, then, that would be what would be followed. But I don't think the failure to do that per se precludes the court from taking into account factors that, go into the exercise of judicial discretion. Because if the legislature meant or intended that there be a specific consequence for a failure to do something mandated, then it obviously can say so. And in regard to the garnishment statute, it did in various sections of the Chapter 77, the legislature states that if something isn't done, then here's the consequence. So by implication, if the legislature doesn't say so, there is obviously no mandate as to what the consequence should be, and the court by default has to make a decision. And I think
Is the
then that's
statute
what
is the statute ambiguous or unambiguous?
excuse me.
Is the statute ambiguous or unambiguous?
Well, I think it is silent. It makes no statement of intention of the legislature as to, like in this particular case, if the notice is filed or served, but done so.
Well, whether it says things or doesn't say things, my question is a little bit more basic than that. Is the statute as written ambiguous or unambiguous?
Oh, I think the statute, in terms of what the statute says, the statutory language, it's not ambiguous at all.
So if it's not, if it's unambiguous, then we'll just look at its plain meaning to see what it says.
Right.
And I think probably the biggest challenge I'm having with your argument is the word must and what the word must means in ordinary and plain language. Can you address that for me?
Yes. I mean, I think in regard to this particular situation or statute, the must refers to the service of the notice. I believe that that is a mandatory requirement. The case law indicates that that is something that the creditor must do, send this notice. Now, I believe that the timing of the notice is of secondary importance, that the must is not so must in that regard. Obviously, the legislature wants there's an intent and purpose you can derive from the language of the statute as to why that notice is intended to be sent. Now, obviously, the legislature is, concerned about expediting the garnishment proceedings because they involve tying up, if you will, someone's property. So there's a time limit within which that notice must be sent.
Counsel, does your proposed construction of the statute effectively eliminate those time provisions?
No, because I believe that they're obviously to be followed, and no creditor is going to willingly, intentionally violate them. But I think that by the legislature not dictating the remedy of dissolution of the writ for the failure to comply with the time period, that leaves open the possibility that under given circumstances, the violation of the time limit is to be excused because no harm is done. It was a harmless error. And that in the interest of justice and the interest of having matters heard on their merits and the interest of preserving the creditor's right to pursue its remedy, that the harmless delay in serving the notice can be excused.
Let me ask you this. You just mentioned having a case resolved on the merits. In this situation, I believe the notice, which was 5 days late, was served on June 24th. Would there have been anything that would have prevented you from serving an amended notice, an amended motion, amended request for writ, within a week after that?
You mean sending another notice?
Starting off.
Or reinitiating the entire
reinitiating the process. And this was already the second time you'd done the process. I think the first had been months before, but would there have been anything preventing you from reinitiating the process right after June 24th when there was realization that the notice to defendant had been served in an untimely manner?
As a matter of law, no. The creditor could file another writ of garnishment. But from a practical point of view, that has at least potential serious consequences because by the nature of a writ of garnishment, it attaches or levies upon, if you will, property that is in the hands of the garnishee within the time period of when the writ is served and the answer filed. So
from a legal perspective, it was akin to a dismissal without prejudice. Would you agree with that?
Yes. But in
I know in practical matter, but that can happen in a typical civil lawsuit. I mean, you could file a complaint, have it dismissed, file an amended complaint. And by the time you get your judgment, you're behind someone else. But
Right.
it's still a dismissal without prejudice.
Right. And so a creditor in a given case, as here, would have to make a decision as to whether it made sense to start over in effect or to attempt to preserve this writ. So in this case, obviously, we elected to attempt to preserve the writ that had been served. So I guess the primary argument is that, I'm asking the court to avoid the law or evade the law. I don't think so, because the law in this particular case is silent as to the consequence of filing the late notice.
Let me ask you this, Mr. Mashburn. I agree with you that the statute seems unambiguous. So it seems to me it says the plaintiff must mail these notices, what plaintiff must mail, and when the plaintiff must mail them. You're taking the, I guess, interesting position that must only applies to mailing the original or mailing a copy, right?
Yes, I'm saying that is the primary intent of the statutory requirements.
So what happens in this case if the plaintiff emails the copies instead of mails them? What's the remedy then? The statute is still silent as to a remedy. So if the plaintiff doesn't mail them, and you said must applies to the mailing, what's the remedy? Does this statute have to provide us a remedy or provide the trial court a remedy? Or is it a condition precedent?
Well, I do not think it's a condition precedent that the mailing of this notice, because the case law, there's cases that say that this requirement can be waived. There are cases in which these notices, both under subsection 41 and subsection 055, which also has a similar requirement of a notice being sent within a time period. There's existing case law, which in cases where the notices were not sent at all, much less sent late, and the court found that that was a technical error and did not result in any prejudice, and therefore remanded the cases for compliance with the statute and the sending of the notice.
Then what effect do we give the legislature's use of the word must?
Well,
Must is mandatory, right?
I think that the must, looking at the statute in a broader sense, that particular statute, is that the notice must be sent. The notice is mandatory. I have no argument with that, because the notice informs the defendant of certain essential rights and allows them to insert at that point a claim of exemptions, which would have a significant effect on the subsequent proceedings. But the timing of it.
Is there a benefit to the defendant receiving prompt notice of their rights to oppose the garnishment action? And is there a benefit to the party holding the assets, the garnishee, to having the case move in a prompt manner?
Yes, in a general sense, but in this particular case, the defendant's time period to file a claim for exemptions does not start to run until the notice is served. So the
notice was served a year later, and there was, the defendant could still have time to seek exemptions, and the garnishee was just left in a position of holding the assets for an extra year. Would that be viewed as prejudicial?
Well, it certainly could. I'm not advocating that any delay, and every delay, in sending the notice is without prejudice. What I'm saying is that the prejudice would be looked at in each individual case. And obviously a creditor has an obligation to uphold its obligations in a good faith and prompt manner. But in terms of the requirements of the statute, in this particular case, the 5 days did not reduce the amount of time the defendant had to respond with regard to a claim of exemption. And in this case, no claim of exemption was made. Also, the 5 days did not result in any delay of the proceeding itself, because this notice is sent concurrently with the time period that's running for the garnishee to file its answer, which is 20 days from service. So again, in this particular
Counsel,
case,
you seem to be advocating for more of a pragmatic viewpoint. I can't say that I'm especially moved by that, although I understand it. I don't know if I'm moved by it at the expense of the plain language of the statute, but let's take the pragmatic aspect of it for just a second. Would you agree that if we adopt your construction of this statute, that basically it creates a situation where there needs to be an evidentiary hearing on every issue relating to this? We're mindful of how backed up the courts are. If we see it your way, are we creating a system in which every garnishment action is backed up by 3 to 10 months so that trial courts can have evidentiary hearings on prejudice?
well, obviously, I think it's going to be an extraordinary case where the creditor is late in sending the notice. This is not going to be the norm. No creditor is going to assume that they're going to be excused from that delay and adopt this as a policy. So I think it would be a rare occasion for the courts to have to consider this. And
but you'd agree with me that we would have to have an evidentiary hearing now in every single situation in which this issue did arise.
well, no, I'm not sure. I think that on the face of some of the situations, such as this one, the lack of prejudice, I think is self-evident. There was no prejudice. I mean, in a case where there is some question as to whether there was prejudice to the other parties, well, then yes, an evidentiary hearing may be necessary, but I don't think that would be required in every case, and I don't think it
Is there,
required in this case.
following up Judge Traver's question, would you have an evidentiary hearing if the garnishee, in this case in the state, 2 co-personal representatives, are they being slowed down in administering the estate? Would they be entitled to a hearing?
Well, I mean, well, I guess that's possible. I mean, anything, I mean, I'm not advocating, I mean, in this particular case, I don't think there's any evidence of prejudice. Could there be prejudice in other cases? Well, certainly. I'm arguing that the rule of strict construction should be flexible enough to allow a trial court in a particular case to make a determination if there's prejudice or not. I believe that in this case, the trial judge felt he had no discretion and simply dismissed the writ regardless of any underlying prejudice or lack thereof. And
Okay. You're down to 3 minutes. Do you wish to say the remainder of your time for rebuttal?
yes, sir.
All right, thank you. All right, Ms. Tromley.
May it please the court? The question before this court is truly, should this court construe a clear and unambiguous statute in a way that would render its statutory time frame meaningless and add a test to the statute in the form of prejudice that's not in it to lessen the impact on an appellant who failed to comply with its timeframes, not just once, but twice, and now another judgment creditor has properly followed the statute and obtained a writ of garnishment. The first time that this his writ of garnishment was dissolved by operation of law, he just refiled. But he didn't just refile. We had a motion to intervene already claiming a superior title to this property, claim from a credit judgment. So what ended up happening is 3 months after this, he decides to file this writ of garnishment. If it was so important, he keeps saying attempt to preserve. He was saying basically a time is of the essence, but yet he didn't make sure to comply with the statute, not just the one time, but both times, even when he knew there was a claim of superiority and priority for this particular asset in play.
Let me ask you this.
Sure.
In their brief and below, the appellant argued the case of Regions Bank versus Hyman, a federal district court case. You believe that case is distinguished? Are you going to argue that case is distinguishable, or do you believe it's wrongly decided, or how would you address that case?
So that case, first off, is just persuasive authority, but I also think it's not only distinguishable and the fact that it's also, I think it was also wrongly decided. So it's about a 30-page opinion. And during that 30-page opinion, there's various issues of garnishment that are coming up. It was a case where the asset was owned by tenants by the entirety, I believe, or joint tenancy. And so that played a big issue in it as well. But the thing that's really with it is it doesn't follow Florida law, and the fact that this statute's clear and unambiguous, and they decided to look into legislative intent and history, and they decided to add a de minimis exemption, which isn't in the statute. They decided to inject a prejudice analysis into it, which is not in the statute. And in addition to that, the way that they interpret it is also against Florida law, because it has the court rendering part of the statute meaningless and acting as a legislative branch, abrogating the legislative branch's rights. It is also distinguishable in the fact that when the writ was served, it was served on 5/17/2013, and they stated that as of 3 days later, the defendant actually had actual notice. Well, the mailing was delayed, he had actual notice. Here, that's not the case, and that hasn't been claimed the case in any of the briefs. So it's different from those things. And additionally, it says, considering the facts of this case, so they didn't use it as a bright line rule. They used it as a, hey, here's this case. But again, it was just a very small part of that particular case. Okay. Unless the panel has any further questions for me, I'll rest on the merits of my brief.
Mr. Traver, Judge Traver, Judge Harris. Okay, let me go ahead and hear then from Mr. Rosales.
Thank you, Your Honor. Your Honors, may it please the court, Fausto Rosales on behalf of appellee Peter Wood in his individual capacity as judgment debtor. The trial court did not err in dissolving a writ of garnishment where the judgment creditor failed to abide by the strict time requirements imposed by Florida Statute 77-041 subsection 2. As we know, it's well settled Florida law that garnishment statutes must be strictly construed. And where the language of a statute is clear and unambiguous, we must give the plain meaning of the words. To do anything else would render the words meaningless. That's the main proposition of the Zivitz v. Zivitz case, which is a case out of the 2nd District with the sister court. At issue today is a very specific wording of Florida Statute 77-041 subsection 2, or what I call the first notice. The statute is plain and unambiguous, and no further interpretation is necessary. Your Honors, the relief sought by the appellant is simply not allowable under Florida law. The interpretation set forth by the appellant would unquestionably rewrite Florida Statute 77-041 subsection 2 by adding new and additional terms and conditions that were never drafted by the legislature. However, prevailing Florida law states that where the language of a statute is clear, we must make no further analysis. We must take the statute as drafted. In this case, the statute requires using the words must, which is the same operative word that was discussed in the Zivitz v. Zivitz case in the 2nd DCA, in order to reach the same holding that we're asking the court to reach today, where a trial court has no flexibility in rendering these decisions. Here, the statute at issue commands that the judgment creditor send within the time prescribed by Florida law the notice to the judgment creditor via first-class mail. And then a judgment creditor cannot reach a final judgment of garnishment without satisfying this provision. And in fact, the legislature wrote into the statute that they must provide a certificate of service proving that this very specific statute requirement has been met. And we have to take a step back. Let's ask ourselves, what standard are we creating by having a judgment creditor who's allowed to file a belated notice provision versus a judgment debtor who has no leeway in having additional time to file a claim of exemption? Where on one hand, there's good cause or an excusable neglect test that the appellant would have this court adopt, where the judgment creditor to be able to show a good cause as to why they didn't provide the notice pursuant to Florida law, versus a judgment debtor where the Zivitz court, which is a controlling law as to the judgment debtor analysis, tells us you have no leeway. even in situations where the facts would arguably obviously support that there should be leeway.
So you would agree that Zivitz was controlling maybe on the trial judge, not on us.
I do, yes, absolutely, Judge. I do believe that it would be persuasive authority as to this court. And I think that, and the position I'm presenting to the court is that the standard imposed by the Zivitz case is one standard that the court should, in the mirror aspect, impose to the judgment creditors, right? Because in the Zivitz case, where you have a judgment debtor who's suffering from clinical depression, is supported by an affidavit from his medical doctor stating that he could not appreciate the deadlines imposed on a litigant at that time. And on top of that, the fact that the funds that are going to be garnished are homestead protected funds, which, as we know, is the golden egg in garnishment proceedings as to being able to stop a forged creditor attachment. Even then, the Zivitz court says that, listen, the judgment debtor had to file a claim of exemption within 20 days. Here, what we are proposing to the court is a judgment creditor must mail within the time prescribed by Florida law under 77041 subsection 2 that notice. And I believe that that is required. And if we do a plain meaning or a plain reading of the statute, it actually says that because it requires that a certificate of service be filed in the trial court. Again, Judge, this would create an unequal standard for a judgment creditor versus judgment debtor. And I think it's important to know, only because your honors had asked the question before, what is the prejudice to alleged windfall to the judgment debtor? I believe the appellant has made a position clear in stating that there's no prejudice to the judgment debtor, and that's actually not true. Number one, they don't have the benefit of the use of the statute as drafted. Number two, it would create this competing claim analysis as to what a judgment debtor can do versus what a judgment creditor can do. And on top of that, I really want the court not to lose sight of the fact that this is not an alleged windfall to the judgment debtor, as the appellant states. The appellant has remedies available to seek garnishment. And in fact, what normally happens is when a judgment creditor notices that it has run afoul of the statute pursuant to 77041 subsection 2, they'll dissolve their writ, they'll immediately seek a new writ, and they'll go ahead and attach. And in fact, there's no windfall here because that's actually what could happen here. In the event that the court were to uphold the ruling from the trial court, Mr. Mashburn is fully within his right to be able to seek a new garnishment, serve it on the garnishee, and the garnishee would then again respond. Would he keep the same claim priority? That's a different question, and it's not before the court, but that is his remedy. He can do that. He's chosen not to do that, and here we are. Your honors, briefly, because I know that I'm running out of time, the relief sought by the appellant would open Pandora's box. I think it's important to talk about the public policy argument. It would prolong litigation amongst garnishment parties, and it would create an uncertainty amongst litigants. And having the litigant ask, is this a valid judgment? Is this a valid garnishment or not? Who has the claim priority? Who doesn't? And it would create this garnishment chaos. What constitutes good cause? It's a slippery slope argument. If 5 days is good cause, is clinical depression good cause as well? For a debtor, it's not, but is it for a creditor? Those are the questions that we would be raising in the judicial chaos aspect that I'm presenting to the court. And in sum, the appellant's proposition is unsupported by Florida law and would render the time requirements imposed by Florida Statute 77041-2 meaningless. It would also force a judicial rewriting of law that simply does not currently exist in the statute. And it would force to establish an unequal legal analysis today. And it would, it would force an unequal legal analysis standard for judgment creditors versus judgment debtors. And accordingly, based on the arguments presented today and the arguments raised in our brief, we would submit that the trial court did not err in dissolving the judgment.
Thank you. All right, rebuttal, Mr. Mashburn.
Yes, sir. The Zivitz case, I think, is distinguishable because in that instance, this particular statute mandated a result if the defendant didn't file a claim for move to dissolve the writ within the 20 days. So in this case, there was no statutory mandated result. And I would strongly argue that Florida law is not inconsistent with the position I'm advocating here. In fact, supports the position. The courts cited the Regions case, which is a federal case, but the reasoning of that case is exactly the reasoning I'm advocating. And there are Florida cases, which the Rude case, Gigliani case, the Beardsley case cited in my brief, which in all those instances, a notice was not given, and the court that was required under either subsection 041 or subsection 055, and the court called it a technical error and remanded the case for compliance with the statute. So if the failure to send a notice cannot is grounds to, in effect, for relief from the failure, then certainly a 5-day late notice doesn't constitute grounds for dissolution. To follow the appellant's argument, in those cases, the appellate court should have dissolved the writ because the creditor did not comply with the strict requirements of the statute. So I would like to, just in summary, plagiarize, if you will, the Regent's case for my argument. The Regent case stated, Judge Kavanovich, she said, the court recognizes that there are cases which hold that strict compliance with statutory garnishment procedures is required, and noncompliance requires that a writ of garnishment be dissolved. There are other cases which recognize that strict compliance with statutory garnishment procedures is required, but where justice requires, considering the facts of the case, additional proceedings to cure a technical violation have been permitted. The court notes that courts recognize that a judgment creditor has due process rights. So that is what I'm advocating here, that in this particular case, based on the particular facts, no harm was done of any kind. The intent of the statute was complied with the notice being sent. The 5-day delay did not cause any prejudice to any party that's been cited. The defendants agreed before the trial court that there was no prejudice, and that dissolution of the writ in this case becomes arbitrary, punitive, and without a rational basis, and violates the creditor's due process rights.
Okay, thank you all, and we will be in recess.